office did not know about this in advance. When I spoke to them on the phone last night, that is not what I heard. What I heard was say, listen, this is a problem for us. We understand, on the quote Mr. Siegel, yeah, there's no reason why you would have not turned this over if you had it, which is correct, and the record would support it. Comparing this, counsel is now discussing and saying how they are being victimized by late discovery. The only late discovery in this case, and the court's aware of it, the court ordered that the discovery be turned over on 2 witnesses. It should have been turned over before the court ordered it.
I don't want to deal with something that we've already done. I understand about the 2 defense witnesses. We've covered that. Just deal with the present issue.
So, what counsel did is, he cited last night, he sent to the court a case called Hughes, 2020 case, 50 Cal Ave 5th at 257. He included no facts about that case. At 2 in the morning, I went and I read the case, and I then sent an email. That case, so the record is clear, involved a situation where there was a Watson murder, and where the defendant was being tried on a theory that his alcohol intoxication had caused the accident. The investigation had been by the MATE team, and they had determined that in fact it was speed and not alcohol. This was a very huge problem for the prosecution because that was the theory of their case. Apparently, the head of the MATE team started redoing a separate investigation, which the evidence suggests the prosecutor was well aware of. At the very least, and as the Court of Appeals said, the prosecutor was given information that in fact the MATE lead detective now had a new opinion, contradicting the prior opinion, that in fact, in actuality, it was caused by alcohol and not by speed. Instead of turning this over to the defense, the prosecutor literally had the witness on the stand in front of the jury. He then pauses, looks over the fence and says, hey, by the way, here's the diagrams and here's the information that he's going to be testifying to. Defense is obviously horrified because it's the entire case. The defense asked for a mistrial. They asked for a continuance. They were both overruled. The Court of Appeals said, hey, listen, obviously the suppression of evidence, as the court is aware and under the statute, is the last option a court can utilize, only after every other option has been determined to be not harsh enough or not accurate enough in addressing and solving the situation. The Court of Appeals said, hey, listen, Judge, you had a chance to do less remedy. You didn't do it. The jury ended up convicting, and the case was reversed. To compare that case to the facts of this case, it is distinguishable for the following. Number one, that evidence was not just inculpatory, it was the entire case. Number two, the prosecutor, for a tactical advantage, which the Court of Appeal basically said in a footnote, that although the original trial judge had found no prosecutorial misconduct, that in essence the record didn't support it, meaning that there was misconduct that the prosecutor did. The prosecutor decided, for a tactical advantage, that he was not going to turn it over. He then did it while the witness was on the stand. He then opposed any continuance or mistrial. Here's what we have. We have evidence, which it is inculpatory. It's inculpatory because the defendant is found at his location, at his house. There is a 9mm magazine for a Glock 43, and there's no Glock 43 to go with it. So it's just a magazine. We already knew that the defendant had the Glock 43 magazine, and we knew that these were 9mm casings. The difference now is that there is going to be evidence that suggests that a Glock 43 is more likely to have put the marks on the expended casings than many other firearms. So the idea that this would be excluded under 352 is patently absurd.
Hawk Volkswagen Joliet is #1 again. That's right, the #1
authority for what they're asking is also absurd. We talked to the lab this morning. First, what we are proposing is that we will not mention this evidence in this case in opening. We will wait and see how the case develops. As the court is aware, and the court is aware of this from the discovery of the witnesses that we got the day before we started trial, the defense is now claiming not only that it was a starter pistol, but they are claiming that the 9mm magazine, which was found at the defendant's residence, actually belonged to